Okay, so we are on to Amendment 6. There are two amendments left. Uh, Normally we do get a little farther than this, but I'm happy just having gotten through the presidency, the Supreme Court, and Congress, and the Bill of Rights. That's a decent semester for. I heard somebody use this analogy for what we're doing this semester. We're putting we're building a plane as we're flying. We're putting this college experience together as we're going through it. With this turned online. So I appreciate your patience and forbearance with me, all of you, sincerely. So Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So there's a lot to unpack here. So the accused, I hope none of you ever find yourself in the position of being the accused of anything. You're going to get a speedy and public trial. You're going to get an impartial jury. An impartial jury means a jury that hasn't made up their mind whether you're guilty or innocent, a jury that is removed enough from events that will render a verdict, hopefully a fair one, about you and the crime anyway that you committed. You're going to have a jury from the state and district where the crime will have been committed. You will be informed of what you did if you didn't know what it was you did. You were going to be confronted with witnesses brought against you. You are going to have the opportunity to question them also. You can have witnesses in your favor. You can have a lawyer. If I might offer, as we near the end of the semester, a nickel's worth of free advice, if you ever find yourself in this sort of situation, be quiet and ask for a lawyer immediately. Do not ever, ever, ever try to defend yourself. It doesn't go well. So, Amendment 6, we just talked through a bunch of rights, a cluster of rights that were designed to make criminal prosecutions more accurate, more fair, more legitimate. These institutions and these practices have changed pretty markedly over the course of our history as a nation. And we've been forced to take a look at how old rights, old legal texts, old things like that, and the Bill of Rights apply to the institutions as they exist now, and how these procedures work in the institutions as they exist now. So at the time of the founding, I mean, obviously a lot of this stuff didn't exist. We've talked about this ad nauseum throughout the semester. There wasn't the facial ID. There weren't automatic weapons. There weren't televisions. There certainly weren't computers. You couldn't watch me like you're doing now. Yeah, there were local sheriffs back then. There wasn't the professional police force. That came along much, much later. Ordinary men, it wasn't women, but ordinary men, they took turns serving as constables or night watchmen. So they take it upon themselves to apply the law as they saw it to their communities. And they did a pretty decent job. So criminal cases were almost always brought by victims, certainly not public prosecutors like they are now. So it's not the state bringing charges against Jonathan Parker. It would have been Jonathan Parker bringing charges against Mrs. Parker. I don't know. Hopefully it never gets to a point like that in my marriage. Not public prosecutors. At trial, neither side typically had a lawyer. So the victims, the defendants, normally represented themselves. So I'd be at one table, The defendant would be at another table, but we'd just shout at each other. We'd have it out. They were like shouting matches, these trials. Victims, defendants, they told their stories. They brought other witnesses in to tell theirs. And these trials were over in minutes, maybe hours. Certainly not the days or the weeks that we have now. There wasn't as much procedure uh, in the way in some cases. So juries were the central players in that system. So they were 12 men in the community who knew the victim and the defendant and other people and places involved. And there's a lot of virtue to a system like that. If say, for example, somebody, got shot and survived but had a brain injury, and they acted a little erratically from that point on. If the townsfolk knew about that and that guy had done something wrong, I mean, they might seek a lesser sentence knowing that that man already was suffering. Whereas if they brought in people who didn't know, well, there might be a harsher punishment. And they also knew they were all very well conversant in the law. They knew the law. They knew which charges subjected defendants to the death penalty, as most really felonies did, which also did not do so. Jurors also, they do their best to keep them kind of separate now from what's going on in the rest of the courtroom, but they also looked these witnesses in the eyes. They would talk, debate right there whether a defendant was factually guilty or whether he deserved mercy or whatever. The jury was the check on the government's power to punish. The jury applied the conscience of the community in the public eye. The jury assured everyone that justice had been done in a swift, impartial, and fair way. Juries, now, if you ever get called for jury duty, here's another bit of advice. There is a thing called jury nullification. A jury is legally entitled, the jury can, if it wants, nullify a law. And that is done if it's a law, say, like the minds of the collective conscience of the American community is starting to shift away from, being for the war on drugs. I think, just from my experiences and who I talk to and things like that. So say somebody is brought up on a charge of marijuana possession, and the jury thinks, hey, this is a pretty dumb law at this point in time. He got caught smoking a joint in his house. Yeah, maybe he should have had the blinds closed or whatever so the police couldn't see, but this is a stupid law. The jury has it in its power, and they won't tell you this at a courthouse, to declare that person innocent, even though they broke the law. That is something that a jury can do in America. And by doing that, the jury has just nullified the law. Simple as that. So, if you want to get out of jury duty, tell them you're in favor of jury nullification. You can't wait to nullify unjust laws. You'll be sent home very quickly. Promise you that. So the framers of Amendment 6 really sought to strengthen this vigorous adversarial process. They created a system that leaves it to each side to conduct its own investigation. I don't know, honestly, whether that's turned out to be such a good thing. to present its own evidence and argue one side of the story in open court. And I say I don't know that that's been such a good thing, because there are so many instances where the judicial system is utterly failed. I don't know that maybe if we went back to just people shouting at each other in a courtroom, we wouldn't get better results. I don't know. That's again just an opinion. That's just my opinion. But yeah, we've certainly evolved. We've created a more bureaucratic legal system. Most of these institutions of criminal justice changed greatly over the decades after the Sixth Amendment was enacted. We had the advent of the professional police force. The professional police force was in charge of investigating crime and arresting suspects, not Citizen Parker, who was the night constable on what's the date? November 29th. Yeah. Public prosecutors also displaced victims. Victims and defendants, too, stopped speaking for themselves. They let lawyers speak for them, which is a good idea. Defendants who could afford it hired lawyers to level the playing field. Now, even if you can't, the state will appoint a lawyer for you, or to you, rather, I should say. We've seen the rise in plea bargains as well. So to avoid a jury trial, to clear the courts unarguably, busy dockets, they have way more than they could probably hear in terms of cases. They plea bargain. So most defendants would plead guilty and get a reduced sentence. So say one of you doesn't like your grade. One of you, threatens me online, makes an improper, and I think this is a thing, an improper online communication, sends me an email. Well, I print that out, show that to the police. We go to court. I know none of you will do this. I'm just giving an example. They might want you to have a week of community service. You might say, okay, I did it. I'm guilty. Plea bargain it down to 3 days. I don't know, just a silly example. So juries really are resolving only a small fraction of criminal cases now. The Supreme Court around this time also ruled that virtually every aspect of the Sixth Amendment applies not only to federal prosecutions, but to state prosecutions. So we have the protection of the Sixth Amendment now in our states. And this vastly expands the reach of Amendment 6, because most of these criminal prosecutions do occur in state court. The federal court system is overwhelmed as well, but most of these crimes are at the state level. So the incorporation of the Sixth Amendment against the states has also required the Supreme Court, to spell out the amendment's protections and apply these protections to the variety of criminal justice systems across the nation, not the nations. So the Supreme Court's probably most significant work has been implementing this right to counsel, your right to have an attorney. They've confirmed that a defendant with enough money can be, generally, has the right to be represented by a lawyer of his or her choice. The accused also has an implied right to forego counsel entirely and defend himself. That is please don't do that if you ever find yourself in that situation. Do not do that. Find an individual who is emotionally unattached to speak for you. What if the defendant wants a lawyer but can't afford to hire one? Well, that's a good question. Gideon versus Wainwright, which is definitely going to be on your final. Gideon versus Wainwright. And again, if you just take this over to YouTube, I don't link it. I mean, I'm just assuming you guys know about Quimby at this point. This, I showed this in the 10 o'clock class. Yeah, any of the first four, if you just pick one, I mean, that'll certainly show you, that'll explain Gideon versus Wainwright and the importance. But because of copyright, I can't do that. But anyway, the gist of the case, of Gideon versus Wainwright, the court held such defendants facing possible prison time are entitled to court-appointed lawyers paid for by the government, whether that be the state, the federal government, localities, wherever the crime is being tried. So no Gideon versus Wainwright for the final. So these public appointed lawyers, these public defenders, they're called, they have to deliver effective assistance. Now, effective assistance is, that's unfortunately very loosely interpreted. They have to adequately advise defendants of potential consequences of pleading guilty. They have to also provide a reasonably competent defense. If they choose to go to trial, the defendants. It's lax what's considered decent lawyering because it's kind of assumed. I mean, you have a right to a trial, that's unarguable. But in a lot of these cases, it's just kind of assumed that it's going to be guilty no matter what. Whoever obviously did it. So courts will routinely condone just very mediocre lawyering. Because of that reason, the conviction, anyway, the guilty verdict or the not guilty verdict, seems to be just inevitable no matter what the lawyer did. So really, as long as the lawyer stays awake at the table, it's decent lawyering. That shouldn't be how it works. Again, the system the founders left us, the system that we have, worlds apart. Worlds apart. So the court also really fleshed out the Sixth Amendment's other requirements, starting with the right to a speedy and public trial. Now, speedy doesn't mean what you think it means. So the Supreme Court quite rightly says that the failure to begin a trial in a timely manner requires dismissing the prosecution entirely. So because that's a little drastic, that is drastic, a drastic remedy. The court has interpreted speedy very leniently. In fact, I don't think leniently is even the right word in this context, but delays of several years are sometimes permissible, which again isn't speedy. It doesn't strike me as speedy anyway. The public aspect of the trial is also, that's been interpreted more strictly. So criminal proceedings may be closed to the public or the media or both for overriding reasons like national security, say, um, I don't know, say that Osama bin Laden, instead of dying in Pakistan, had been brought back to the United States to stand trial. Nobody would have been allowed within 10 miles of that. Public safety, victim serious privacy interests. So like if it's a small kid or something, it's traumatizing enough going to court for any reason. It's not a fun place to be. So they might clear out the courtroom if a small child was going to testify about something. So the compulsory process clause also lets defendants subpoena witnesses to force them to testify at trial. Now, this is from personal experience. So just if you have to testify at a trial and your work won't let you out to go do that for whatever reason, they should, but if they don't, ask to be subpoenaed. And that is a document that they have to obey. Another nickel's worth of free advice. So this clause, combined with other constitutional provisions, also now impliedly guarantees defendants the right to testify in their own defense should they wish to do so. The confrontation clause requires these prosecution witnesses to testify under oath and subject to cross-examination. And here also, except for small children, really, who would be traumatized by the process, they have to testify in court and in the presence of the defendant. This case, don't worry about so much. I mean, know what it generally is about, but I'm not hitting that too hard on the final. So to preserve the integrity of the confrontation requirements, the court held in Crawford v. Washington that the prosecution can't introduce out-of-court statements by non-testifying witnesses whose statements are testimonial in nature. So that means when statements were made primarily to establish facts for the criminal prosecution. So if maybe the police investigate a crime and a witness identifies the defendant in order to have him arrested and charged, the prosecution can't use that statement as evidence in court against that defendant unless a witness is brought to court so that the defendant can cross-examine him. So you can't use it, but you can if you can bring the guy to court so the defense can have a crack at him as well. And the compulsory process and confrontation clause also guarantees the right of the defendant to be in the courtroom throughout the duration of his or her trial. Though the defendant certainly can forfeit that right by behaving badly in the court. So if the defendant, maybe shouts, "This court has no authority over me," or sets fire to something, I mean, it would have to be pretty drastic, but defendants are kicked out of the courtroom from time to time. So that leaves the impartial jury. So the court has held that this right applies whenever the accused faces more than 6 months imprisonment, and it applies to any fact other than a prior conviction that would affect the permissible sentencing range. So more than 6 months, you get a jury. If something new comes up, new evidence or whatever that would, say, change your sentence from 1 year to 6, you get a jury. You get a trial by jury. And the jury has to come from a pool that represents a pretty good cross-section of the local community. A jury can consist of as few as 6 people, though nearly all states do require 12. The jury trial clause, combined with the due process clauses of Amendments 5 and 14, they forbid convictions unless the prosecution proves every element of a crime beyond a reasonable doubt. That's a very high bar to meet, beyond a reasonable doubt, and it should be high. If there is a doubt in your mind that whoever it was might not have done it, if you're ever on a jury, you have a duty to say not guilty. I mean, yeah, I mean, that's all there is really to it. If there is a doubt in your mind as to the guilt of an individual, you have a duty not to convict. The jury's verdict also has to be unanimous, though the Supreme Court declined in 1972 to enforce that requirement against the states. So Louisiana, Oregon, I think one other now too, I can't think of it right off the top of my head, have continued to allow non-capital convictions, so non-murder trials, by 11-1 or 10-2 votes. A jury also retains the power to acquit, and this is what I was talking about earlier. This is so important, so important, not just for purposes of this class and its final, which this will certainly be on, but just in life. A jury retains the power to acquit, regardless of the strength of the prosecution's case. They can also return very logically inconsistent verdicts to mitigate punishment. So going back to the example of the guy who was busted smoking marijuana, the state might demand 5 years and $100,000 fine. I just pulled that out of my head. That has no basis in fact. The jury can say maybe time served, meaning he's paid his fine, and no fine, or he served his time and no fine, meaning he doesn't owe any money. That would be logically inconsistent. Or they could say not guilty, which would be logically inconsistent because if there was a witness or two that saw the guy do it, a jury has a lot of power, folks. So the Supreme Court, though, has refused to hold that the Sixth Amendment entitles defendants to have juries instructed about that power or even advised about the sentencing consequences of the charges. So this is why I'm telling you, because they won't necessarily tell you in the courthouse. So while juries have continued to serve the role as fact finders, they are left to perform their traditional role as circuit breakers, so making sure the power of the state and the rights of the individual, there's something in between there. They have to perform that role in the state's justice system, largely in the dark. So remember, juries have power. And that is the Sixth Amendment.